Item number 1 for judgment, CRL 715 of 2020.
The prosecution has meticulously established a robust chain of circumstantial evidence that formally points to the appellant's guilt, fulfilling the standards set forth in Sarad Bridhichand Sarra versus State of Maharashtra. Each circumstance, from the forensic findings to witness testimonies, aligns solely with the hypothesis of the appellant's involvement in the crime, with no reasonable alternative explanation. The conclusive nature of the evidence, including antemortem injuries on the deceased, the appellant's minor injuries inconsistent with his rescue claim, and the appellant's immediate call to the police instead of seeking medical help, collectively negates any hypothesis of innocence. Therefore, in all likelihood, and based on the well founded evidence, the prosecution has decisively proved the appellant's guilt. It is pertinent to note that Section 106 of the Evidence Act serves as an exception to the general rule that the burden of proof lies with the prosecution. Under Section 106, if any fact is especially within the knowledge of a person, the burden of proving that fact lies upon him. Section 106 of the Evidence Act applies particularly in cases where the accused is in a unique position to explain facts or circumstances that are otherwise difficult for the prosecution to establish. Therefore, in circumstances such as those presented here, the appellant is expected to provide an explanation for the events with his exclusive knowledge as required by Section 106 of the Evidence Act. The appellant's action following the incident further reinforce a strong link to his culpability. His repeated absence and delays in appearing before the court, alongside witnesses turning hostile, reflect a pattern of evasion that is inconsistent with the behavior of an innocent person. By invoking Section 106 of the Evidence Act, the prosecution rightfully argued that the appellant, being in exclusive control of the household and present at the time of the incident, bore the burden of providing a plausible explanation for the death of his wife. However, the appellant's narrative of suicide was unsupported by both forensic evidence and witness testimonies, leaving the prosecution's version as the only plausible conclusion. I am also persuaded by the advice of my brother and has mentioned this part. A disturbing fact before parting with the case is the glaring reality that the witnesses have gone hostile and the appellant has been persistently avoiding court proceedings. The appellant was released on bail on 1/11/1995, despite the order dated 27/10/1995 directing the case record to be placed before the presiding officer on 10/11/1995. It was not presented until 20 September 1996 when the final form was received by the court. Upon notice, the appellant failed to appear before the court on 6/1/1997 and subsequently filed repeated petition requesting time to appear from 6/1/1997 until 26/11/1997. When the appellant did appear on 26/11/1997, the case was adjourned to 15/12/1997 for supply of police paper. However, he continued to be absent, represented solely by his lawyer. Due to his continued absence, despite repeated notifications from the court, a non-bailable warrant was issued on 22/3/2003. Unfortunately, this NBW remained unexecuted until 23/8/2013, when the trial court issued an order directing the petitioner to be released upon his appearance. The case record was subsequently transmitted to the Court of Session on 27/8/2013. The case record reveals a disappointing lapse in adherence to the legislative mandate of Section 309 of the CRPC, which stipulates that the trial should proceed on a day-to-day basis to ensure timely justice, despite the fact that the forensic science laboratory was situated only a few kilometers from the trial court. The case experienced repeated adjournments due to the unavailability of the original chemical examination report without a diligent effort to secure its prompt production. Moreover, the delay in examining the witnesses spanning nearly 4 years from the first witness being examined on 24/6/2014 to the last on 12th February 2018 exemplifies an unacceptably depressed pace that fails to meet the standards expected of a fair and expeditious trial. The accused statement, recorded as late as 28/3/2023, reflects a gross departure from the timely trial obligations, raising serious concerns about the trial court's commitment to judicial efficiency. While it appears that the appellant may have contributed to certain delays, the trial court's passive role in permitting such prolonged adjournments cannot be overlooked. This regrettable delay undermines the justice system's ability to uphold procedural mandates. In the light of the above discussion, the conviction of the appellant under Section 302 and 201 of the IPC stands firmly substantiated. The impugned order and judgment of the Third Additional Session Judge Bhubaneswar in criminal trial number 268 of 2012, dated 27/6/2023, being consistent and akin to the evidence, both in fact and law, cannot be faulted with, and in our humble opinion, the same meets the requirement of law with regard to the circumstantial evidence is accordingly confirmed. The appeal stands dismissed.
I agree.
At a land acquisition matter, land has to petitioner being land outside claims for job. The outsiders provided job, the petitioner is not being provided job, pleadings completed manner.
CMFL for adoption.
It's some trace admission.
Trace admission.
And this matter of criminal appeal extension of time.
Criminal appeal for
Extension of time.
extension of time. You are on bail,
My lord.
interim bail.
My lord.
You want it to be extended.
My lord.
Give it.
Bless me.
Pardon to mention one review petition, my lords. I have filed in writ petition. My lords, what has happened in this case? This matter is a surfacey matter related to Surfacey Act.
No, review petition that is in our assignment.
Lordship, this order has been passed by this honorable bench.
Oh, it is not in our assignment.
My lord, but the impugned order is passed by
It
this
was passed
honorable
by
bench.
this division.
This,
Okay.
Division
Yeah.
bench is that.
my lord, Surfacey matter.
Please give it. Give it.
Compulsory retirement of a judicial employee.
Hmm.
It is 20. Land acquisition matter for trace admission.
Good, I will pass.
Item 8.
No.
I require some time for instruction, lordship may after 10 days.
Any interim order?
No. It was yesterday, option was there, but nobody turned up, so I negotiating with the
Mr.
bank.
Arun Kumar Patrol and counsel appearing for the petitioner seeks for an adjournment put of this matter on
10 days. 10 days.
with this matter we commencing 11th
Yes.
11th of November 2020. Yes.
Item number 2.
May I please, madam? Madam, yesterday I examined this matter and there is appellate forum to file this.
The Lieutenant Counsel for the petitioner submits that since against the impugned order, there is a provision for appeal. 6 permission withdraw this writ petition to approach the appellate authority. In view of such submission, the writ petition is disposed of giving liberty to the petitioner to approach the appellate authority. Yes.
Madam, if limitation is there, then
No.
It will be taken.
much obliged.
Item number 3.
May I please? Lord, I am challenging the recommendation of the Land Allotment Committee, led by under Annexure 11 by recommending my plot, my residential plot, to be leased out in favor of a hotel respondent, that is opposite part number 5, and inviting objection under Annexure 12, the objection notice under Annexure 12. But in this case, it is a long history.
No,
I have prepared a
we are
date
not
chart.
going to the history. But this notice is dated 2021.
21.
Why are you coming in 2024? And
But
what happened to this?
24, because
What happened thereafter?
I was totally ignorant about the notice.
No, what happened, Land and Council? This notice was issued.
Yes,
This is a publication of the final list, and this was published in 13/5/2021.
13/5/2021.
3 years and about 6 months are going to be passed in the meantime. So, what is the status of this proceeding or whatever it may be?
But this proceeding, the land has not been finally allotted, and it has been recommended to the government. And in the meantime, after knowing about that notice, when he tried to interfere in my possession, I approached the civil court where my suit is pending for declaration of title. That is at Annexure 13.
Yes.
The civil court said that since the allotment has not been made in his favor, so therefore,
So what
at
you are
this
challenging
stage,
is it the Annexure
already there
13?
in
You have
But-
already approached a court.
yes,
The civil court is in session over the matter.
yes, ma'am.
So what relief you are expecting from us?
That expecting, because the civil court is not inclined to implead the
Then
respondent
against
opposite
that
part number
order,
5.
against that order, it is maintainable. Against the
No,
order passed
that-
by the Land and
I am not
Council,
challenging that order.
Then
I am challenging the very
no, why have
allotment.
once you have approached the court relating to
But
the
not-
same issue, and the court has passed an adverse order against you, you should approach the higher forum.
That not
which are
against
available.
against that issue. I have not. I want to implead the opposite part number 9 as party in the suit.
Why have you filed? What is your prayer in that title suit?
That the title suit for declaration of title, and the civil court has granted the order of status quo
Mr. Sahu,
in respect of the property.
the civil suit is pending since 2001.
That 2001, 2005, the injunction order was passed.
Maybe.
Thereafter, that
2001.
2001
Already
suit is
23
pending.
years have passed and declaratory suit has not been completed.
It is not been completed.
How?
That is fact.
No, that is fact means what step you are taking from the side of the.
We are
plaintiff.
taking all steps now. It is at the stage of evidence. It is at the stage of evidence. Now it is at the stage of evidence. Let a permanent injunction decree in my favor since 2000. Your Lordship can see.
In spite of that decree, suppose the authority has issued that notice which you say under Annexure 12.
It is a
Did you-
public notice. Public
Did you
notice
file
in
any
their
objection to
notice.
that? Did you file any objection? We want
Your Lordship, may I pray one thing?
Yeah.
Your Lordship may permit us to file the objection before the
No, we
authority.
do not know.
No.
Maybe that it might have been disposed of. Who knows?
No, it has not been disposed of.
So
But I have taken a specific stand in.
As my brother is also saying, my lord
Yes.
is saying that you are already submitted. You have already submitted before the court of competent jurisdiction.
The competent
And
jurisdiction
each of the matter coming out of that is subject matter of the civil suit. Why can't you go there?
well, therefore I filed an application to implement that opposite part number
And it
9,
is rejected.
who is interfering in my possession. The civil court has said that at this stage, whether the land has been allotted to
Correct.
that opposite part
Correct.
number
Right
9 or
question.
not, that is not known.
That is
Still
the right
either the-
question.
So therefore, there is no cause of action to implement the
So
opposite
that
part
means there is a rejection. There is a rejection of that.
there is a rejection of that.
Against that, you have no cause before the writ court.
No,
He will call
this
the-
petition, perhaps I am not able to appreciate it.
Challenging that order. That
Well-
means you are not agreeing. You filed a petition for somebody as a party that has been torn down. And you are not challenging that order. So you are satisfied that the court has passed the right order.
No, court has said,
Then
the court has said that the court not rejected my application. Court has said that this is not the proper stage to implement him.
Whatever amounts to rejection.
Rejection.
No, stands rejected. is devoid of
stand
any merit
rejected
and accordingly stands rejected.
the observation that it is not the proper stage.
Whatever, ground.
Because the land has not been allotted in his favor. So therefore, I am continuing in possession. The GA department is a party to that
So
civil
now,
suit.
if you come to that annexure 12,
Yes,
which is in the year 2021, just read out its content.
Yes,
Please read it out.
I am directed to invite a reference to the subject noted above and to send herewith copy of the final list of allottees drawn up by the Land Allotment Committee in their meeting held on 6/5/2021 for publication in the notice board of BDA as per the provisions of the Rule 4(6) of the OGLS Second Amendment Rules 2020 for information of the general public and submission of objection, if any, before the GA and PG department within 15 days from the date of publication of the notice for taking further course of action in accordance with Rule 4(7) and 8 of the above rules.
So the time stipulated was
expired.
only 15 days. So
That
that
is
is over. Thereafter, they might have taken the next course of action.
Next
that
course
has
of
been stated.
action, they will send it to the government for approval.
Where have you stated all those things? What is the start? That is why we want to know that since it is a notice, public notice of the year May 2021, and we are in October 2024. So what has happened?
Lord,
in
my
the meantime,
instruction
if
is
you do
till
not
today.
state anything, the writ petition and just make an oral submission. How can we pass any order on
No,
that?
I have stated in my writ petition that till today it has not been approved by the government. Approved by the government. Till today it has not been approved by the government. And it has not been recommended also to the government.
Suddenly appears that you suddenly rose from the deep slumber and came to this court after 3.5 years.
A rustic person, she do not know whether notice has been issued
He's
or
quite aware of his position.
and it is a
Approaching
I
this
think
civil
tooth
court.
and nail.
but civil court from there is a permanent injunction decree in my favor.
Correct. So go for the violation. Go for the
And,
violation.
most important thing is that after this 13.5, there is another order perhaps passed in 22/12, 21/12.
By this honorable court, madam.
Yes,
Lord,
that
protecting
was
my
passed and that was
possession.
challenged before this court.
Lord,
That is annexure 9.
No, repeatedly they are issuing the notice for eviction.
So if
That-
a subsequent notice has
Yes.
been challenged by this court, so at that point of time, we could have challenged this order.
No, this order was
Yes.
that is an
13/5/2021 ର ଗୋଟେ order, ତା ପର order ହଉଛି 21/12/2022
5 4 22.
5/4/2022 against the appellate order. Against the appellate order in a
the
PP
court has
proceeding.
already said. Again, here also
That
it
it's
is
a
said
fact you could not know about the publication of this notice. This notice is totally not aware of this notice.
We expect Mr. Sahu to guide us.
Instead,
it is a fact.
ଘରେ ଘରେ ସମସ୍ତଙ୍କ ଘରେ
No, that it is a public notice in the notice board. He could not know about the issuance of this notice.
ଓଡ଼ିଶା ସମସ୍ତଙ୍କ ପାଇଁ ସମସ୍ତଙ୍କ ଘରକୁ ଯାଇ ଦେବେ.
That amounts to service. That is how a public notice is there. We cannot take that ground that it has not been notified.
And that is also
That is how the paper publication and public notice is there.
That is also subject matter in the suit, my lord.
The status quo order is there. But I am not disputing that suit, that is a status quo.
That this notice has also been taken care of.
Yes, it is there.
Yeah, that is he pointing out to you. So,
Well,
he
may I
said that
request
I'm not
one thing?
aggrieved by that order of the civil court. If you are not aggrieved, if that order was considered in that civil suit, order
Because
was passed, and you
Lord,
said
the
that
civil
you are
court
not
was of the opinion that since no allotment has been made in that in person of in his favor, the opposite part number 8, allotment has not been made, so therefore there is no question of impleading him as a party.
That means the court has turned down your prayer.
Turned down
So
for
the next
impletion of
course
the
of
party.
action has to be followed.
So far as
How
the
can
action
you
of the
be-
GA department is concerned, my lord, what I am
No, you cannot
what
take
I am
out
requesting
one-
before your lordship may permit me to file an objection before the authority.
No.
provided that stage has already
gone.
already
There is a
15
there
days
is
time
there is
was
also a
granted in
power of review.
2021. How
There is
can-
also power of review by the government.
ଆରେ ତାପରେ
file
ଯଦି
it.
subsequent action ନିଆ ହେଇଯାଇଥିବ who knows? 21 ମସିହାରେ ଗୋଟେ ପବ୍ଲିକ ନୋଟିସ ଇନଭାଇଟ ହେଲା 15 ଦିନ ପାଇଁ ସମୟ ଦିଆଗଲା ତାପରେ କୁହାଗଲା ଯଦି 15 ଦିନ ଭିତରେ ଯାହା ଆସିବ ସେଇ ଅନୁଯାୟୀ ତାପରେ ଫଲୋ ଅପ୍ ଆକ୍ସନ ନିଆଯିବ
Follow up action
ଆପଣ
means
କହିବେ 3.5 ବର୍ଷ ପରେ ମତେ ଗୋଟେ ଅବଜେକ୍ସନ କରିବା ଦବାକୁ ସ୍କୋପ ଦିଅନ୍ତୁ we do not know what has happened in the meantime 3.5 years have passed
that I have stated on affidavit that this land has not been allotted.
without ascertaining anything can we pass that order that you will be given an objection
No,
If
there is a power of
All right.
review provided
All right.
under the
Then
rule
what prevented you to file the review?
that
You
the
could have filed a review.
against the order of approval. Lord. The review is against the order of approval.
That means this is not the stage.
That is not the
So-
state. Till today, the approval has not been
So
back.
how can we grant this? The stage has
Lord,
not come.
my only prayer, my Lord, I will file an application. They will consider on in its own merit.
that period is already over since long. The writ petition has been filed by the petitioner Suwancho challenging inter alia the order dated 13/5/2021 passed by the Directorate of Estates and ex officio additional secretary to government. That is opposite party number. Who is that opposite party? Director, that is opposite party number 3.
Yes, ma'am.
Opposite party number 3. In issuing 38. Issuing public notice for submission of objection, if any, before the GA and PG department within 15 days of the date of publication of the notice for taking further course of action in accordance with Rule 47 and 8 of OGLS Second Amendment 2020. It appears that the petitioners have approached the Civil Judge Senior Division LR Bhubaneswar in PS number 267 of 2001 and the order dated 14/8/2024, which has been annexed to the writ petition, shows that they filed a petition on 2/8/2024 under Order 6 Rule 17 for seeking necessary amendment to the plaint and the London Civil Judge Senior Division. In that petition, they made a prayer. They brought to the notice of the London Civil Judge regarding the notice, impugned notice under Annexure 12. And the said petition has been rejected and the case was posted for filing list of witnesses along with affidavit evidence of PW1. Mr. Sahoo Learned Counsel for the petitioner submits. When a query is made to the Learned Counsel for the petitioner, he submits that he has not challenged the order passed by the Learned Civil Judge, order dated so and so before in any forum. The time stipulated in the impugned notice under Annexure 12 is already over since long, and we are not in a position, we are not, nothing has been brought on record about the status of this proceeding except the submission made by the London Council for the petitioner. That what do you say, Ewan?
Let that till today it is recommended to the government. Government has not approved.
That though it has been recommended to the government, but the government has not approved the same. Mr. Sahu submits that he may be, the petitioners may be given an opportunity to file objection to this public notice under Annexure 12. The time stipulated in the said notice is already over, and subsequent action might have been taken, and therefore at this stage the prayer made by the petitioners to give an opportunity to file objection cannot be entertained. After hearing the learned counsel for the party and going to the amendments made in the writ petition, we don't find any merit in the writ petition accordingly stands dismissed. Yes.
That may I submit one thing.
Definitely.
There is a power of, there is a provision for review.
Item number 4.
If the order has been taken,
Whatever remedy is available to take to him. Yes, next item number.
let your lordship kindly observe that whatever remedy available, he will take that.
Petitioner is at liberty to seek appropriate remedy
Yes,
available to him, them in accordance with law. Yes, next.
Item number 4.
Thank you.
Yes, Mr. Bajaj.
I have challenged the order of the DRT
Hmm.
condoning the delay, and I cited the decision in WPC 8100 by 2019 of this court. And my friend state was
Yes, ma'am.
directed to see whether if any SLP is filed against this judgment or any contrary
Regarding
decision.
to that query, Lordship, no SLP preferred by the.
Yes, any other contrary decision?
Yes, my lord. Thereafter, I was going, and that judgment which referred by this honorable court, that was also found by another judgment in 2021 of Supreme Court.
Hmm.
Both the judgments are that I will give.
Yes.
My lord, next query was to me that whether what is the present legal position of this.
Hmm.
To that effect, my lord, I was going through several judgments, and in this judgment,
No, you must meet this point.
yes, ma'am, I'm going
That
to.
whether the limitation act is applicable to a proceeding under section 17 of the Surface High Act or not. So if 13(4) notice is challenged beyond the period of 45 days before the DRT, whether the DRT is empowered to condone the delay and register that essay or take up that essay on merit. That is the first.
Till 2022, my lord, the apex court judgment is there that it is not maintainable.
Yes.
Section 5 is not applicable to section 17.
So that decision.
But now this judgment, your lordship, kindly have a glance. Another SLP is pending relating to this aspect, your lordship.
Oh.
Lordship, kindly come to
This
page
is Madhya
Madhya Pradesh High Court. In this case, that reference is there, your lordship.
Which what
Clause
reference?
2.1, your lordship. In
Page?
page 4.
Page 4.
Hmm.
In a
2.2.
to 1.1, your lordship.
Hmm.
In a similar.
In a similar controversy, this very bench in MP so and so, they had declined to consider the applicability limitation act to an application on 17.1 in similar content pending adjudication before the apex court in SLP number so and so and KG George and another case.
Hmm.
I ascertain that aspect also, my lord. That case is still pending. This is the status.
Yes.
এটা দিতে এটা দিতে এটা দিতে
Have you
and
thoroughly
in this
scrutinized? In fact, there are some judgments referring to section 24, a general law to be made applicable.
This is that matter where it has been referred to the and it is pending.
Yes.
no, that is sorry, hold it. My lord, in this case, what has happened? That is, I'm giving. This is the copy. Not wrong with it. That is pending, Your Lords.
Scale just case
My
pending.
lord, that is pending. In this case, my lord, which I have given the Jabalpur case, in this case, what has happened? The DRT has rejected the application that section 5 is not applicable to 17(1), challenging that he has come to High Court in 226, where the Honorable High Court has stated, though 18 is there, you cannot come to High Court directly. And that order was also challenged in Supreme Court, my lord, and Supreme Court also affirmed. This is that.
That means he has no remedy before this court. Instead, to go refer to 18.
My lord, he has to go to 18. That is the other thing I had given. Yes.
You see, we'll give you another decision of the Supreme Court. That it is Bank of Baroda versus Parashadi Lal Tursiram. It is civil appeal number 5240 of 2022. And this was decided on August 11th of 2022. Justice Gawai and Justice P.S. Narasimha.
Yes, I have got a copy of that decision. There it says the very scheme is that Limitation Act is out.
Here, what has happened in paragraph number 7, it is stated that after hearing the company, its director and legal representatives of the deceased director, the DRT dismissed section 17 application on the grounds that it was filed beyond the statutory period of limitation of 45 days. According to section 17(1), a period of 45 days is mandated to commence from the date on which a measure under section 13(4) has been adopted, which in fact in the present case is the date when the secured asset is sold in favor of the respondent number 7. So that order passed by the DRT was challenged before the BRAT, and the order of review was challenged before the DRAT, which found no difficulty in allowing the appeal on the ground that there has never been an error apparent on the face of record in sworn in review judgment. It is this order of the DRT was challenged before the High Court. So, not maintainable, DRT confirmed, challenged in the High Court. High Court said that High Court allowed the petition. That means
High Court
state that
High Court stayed the order of
the
order of the
proceeding of
DRAT.
the DRT, and so then it came to the Supreme Court challenging that. Then the observation of this Honorable Supreme Court is like this. We are only concerned with a limited question as to whether the High Court was justified in passing the interim order. Interim order means interim order of stay of that DRT proceeding, where the company with its independent identity is contesting the proceeding. It is apparent that the director were also contesting the matter by filing section 17 application. So there it has been stated in the paragraph number 12 that reason for providing the time limit of 45 days for filing an application under section 17 can easily be inferred from the purpose and object of the enactment. In Travancore versus Union of India, that is 2008 1 SCC 125, this court held that the SurfaceI Act is enacted for quick enforcement of the security. It is unfortunate that the proceedings where a property that has been brought to sale and a third-party right created under the provisions of the Act have remained inconclusive even after a decade. So that means they speak ultimately that that is your. So the appeal was allowed, and that's interim order that was passed by the High Court was set aside. So that means this what it means to say that that is not applicable. That is exactly the
Yes,
contention of
that holds good
So-
till today. Now that
so
this
the
is pending.
tribunal DRT, he has condoned the delay. Now, if in view of the decision of the Honorable Supreme Court, uh, the a petition which is filed beyond 45 days is not maintainable, and in spite of that, or is entertaining that petition, then means he lacks jurisdiction. If any order is passed, even if an appeal provision is maintainable, whether this court in exercise of the power in the writ jurisdiction can entertain such order or not. Merely availability of an appeal provision. There are so many decisions. Merely availability of an appeal provision does not debar this court entertaining a writ petition if it goes to the root of the matter. If the authority lacks jurisdiction
And he
and he has entertained the file. The question is that when that proceeding was initiated, whether the that authority, DRT, has the authority to entertain such a petition because it was already delayed, right? So he has entertained, not only entertained, he has condoned the delay, and so that order is challenged. So he has stated that why I will go to the DRT, why this writ petition will not be entertained, apart from the decision which he is citing. So
And that decision was also in a writ petition.
So that is the crux of the matter. However, we are issuing notice, so just examine the law.
Because the statutory authority has acted on a power which is not vested in him.
Yeah, at that stage, he cannot entertain such a petition. If it is within 45 days, he has authority. If it is beyond 45 days, cannot entertain. He cannot condone the delay. So the question of entertaining such a 17% does not arise. So that is the decision of this. It is for a quick remedy that the Surface Eye Act is. And if you go on condoning the delay, today it is, let us say it is six months, or it may be 1 year. You may file a medical
So things will dilute.
And once you entertain and stay the matter, then what will happen? This banks will take the subsequent action.
Right.
Bank will take the sale. All those things will be naturally sell. So the auction purchaser who has spent so much of money in getting the property, he will be deprived in enjoying that property. So that goes to the very purpose of this act would be frustrated. So that is why they said that no, in this it's a special statute, you cannot entertain limitation as to the 1 year.
After the auction, a right has already accrued in his favor.
All right.
Some purchases are in possession since long.
Hmm.
I am for the
Hmm.
bank there with CORAM file.
This writ petition has been filed by the petitioner Ratnakar Shanapalli, challenging the order passed by the Land and Debt Recovery Tribunal Cutter in order dated 8/5/2024, Debt Recovery Tribunal in IN number 1900 of 2023, bracketed example NDN number 1043 of 2023, in which the Land Tribunal has been pleased to allow the interim application filed by the petitioner of that interim application, who is now the opposite party number. Here, what an opposite party?
678.
6-7. Opposite party is number 678. And condoning the delay in filing the essay. The Mr. Mishra Land Counsel for the petitioner submits that the learned presiding officer has relied upon the decision of this court passed in WPC number 31580 of 2023. December को अलग वाली date थी ना? Thanks. You have given that December.
yes yes ସେଟା ସିଏ ରିଟ୍ ପିଟିସନ ଫାଇଲ କରିଥିଲା ଏଠୁ ଲିବର୍ଟି ନେଇକିରି
And the December आपण काय date
Page-
ला होती
ପେଜ 26 ରେ
for that December.
ପେଜ 26
I have that copy.
page 26 I have annexed.
No, that is not it. I have given.
The decision on which I am relying.
No, you said that the division bench has stated that Justice Sadangi and Justice. No, this is. କାଲି ଆପଣ ଏଇ ଡିସିସନଟା ପ୍ଲେସ୍ କରିଥିଲେ ନା କଣ?
ସେଟା ଆରଟା ଜଷ୍ଟିସ ଚିଫ ଜଷ୍ଟିସ ମୁରଲୀଧର and justice KR Mahapatra's decision, that is at flag B. WPC 8100.
DRT was in error in condoning the delay.
Yes. Paragraph 29.
2030, paragraph 30. Place, Clarence counsel for the petitioner place the decision of this court in case of branch manager urban cooperative bank versus registered executive sponsor in the observation of the council, wherein it has been held that neither section, the page number which you borrow, neither section 17(1) of the SFSI Act or section 31 of RTB Act permits the DRT to condone the delay in filing an appeal beyond the prescribed period. And therefore, the DRT was in error in condoning the delay and allowing the opposite party number 2 proceed with the appeal filed by her before it. The land counsel for the petitioner also in case of Bank of Baroda and another versus so and so in civil appeal number so and so, it has been held that the reason for providing a time limit of 45 days for filing an application under section 17 can easily be inferred from the purpose and object of the enactment. In Transcore versus Union of India and another reported in 2008-1 SCC 125, the Supreme Court held that the SFSI Act is enacted for quick enforcement of the security. In the aforesaid case, the stay order passed by the High Court in the was set aside. Stay order passed by the High Court in the writ petition to the proceedings of the DRT was set aside. Stop. The London Council for the state was asked to examine as to whether there is whether against the order passed by the division bench of this court in WPC number 8100 of 2019 Branch Manager Urban Cooperative Bank versus Registered Debt Report Tribunal by order dated 12/5/2021 was challenged before any higher forum or not, and whether there is any contrary decision of the Honorable Supreme Court, the Land State Council has produced an order of the Honorable Supreme Court in the case of the judge and another versus authorized officer Indian Bank in SLP so and so, which indicates that the said similar question is sub judice before the Honorable Supreme Court. Law is well settled. The Land Council for the state, however, submits that that if the petitioner is aggrieved by the order passed by the DRT under section 17 of the SFSI Act, he can appeal to the appellate tribunal, and therefore the writ petition is not maintainable. The contention of Mr. Mistral and counsel for the petitioner is that since the DRT has no power to entertain the appeal under section 17 of the SFSI Act beyond a period of 45 days of the issuance of section 13(4) notice, and has no power to condone the delay and the filing of such a case, he could not, the DRT could not have entertained such a petition, and lacks jurisdiction to entertain the petition. And therefore, even if the alternative remedy is available to the petitioner under section 18, this court does not lack jurisdiction to interfere with the order passed by the DRT under Annexure 6. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Mr. Swanso appear here upon who appear
4 and 5
4 and 5
bank.
Not at the
Arvind.
have you filed your
No, not today. I have undertaken.
submits has instruction to appear for opposite party number 4 and 5. No notice be issued to the opposite party number 1. Land Council for the state accepts notice for opposite party number 2 and 3. Extra copies of the writ petition be served on the Land Council for the state. So far as opposite party number 6, 7, and 8 are concerned, requisites for issuance of notice by speed post with proof of delivery shall be filed within a week. Matter will be listed in the week commencing 4 सप्ताह पर दे दो है ना the file an application for stay.
Yes, madam.
IA number shown, so there shall be stay of further proceedings of so on until further orders.
Extra copy we subs.
And in support to that matter, I filed a judgment of Jabalpur High Court and confirmed by in the SLP. That may be kind.
I would ये add कर देंगे. The council for the state has also proceeding the decision of the division bench decision of the Madhya Pradesh High Court on similar point.
And confirmed by in
Which
SLP.
shows, which indicate that beyond the period of limitation that cannot be entertained.
No,
That is
section 18.
The DRT section 18 application is to be filed.
Achha.
That was
Section 18 has to and data taking that has been confirmed by the honor.
Yes, sir.
Yes.
Hon'Ble.
Yes.
Item number 5.
Artificial officer dispose of several matters that is enhance compensation.
Item, yeah.
Here it is representation
My lord,
annexure 11.
Annexure 11. I have given that.
The annexures, ଯୋଉଟା ଦେଇଥିଲେ ତା ଦେହରେ annexure 11 ଅଛି ନା?
11, I-
ଠିକ ଅଛି, ତାହେଲେ same order.
AUW.
Item number 5, same order to be done. Yes.
Item number 6.
My lord, in this case, the compensation was awarded to the petitioner and he was received part
ସେ mic ଟା
compensation.
ଶୁଭୁନି କି କଣ?
He was received part compensation, my lord. For the balance compensation 50 lakh 42,000, he approached this honorable court. And this honorable court directed
To pay the balance.
to consider the representation, my lord. And when the opposite party didn't consider the representation, the petitioner filed contempt. And in contempt, my lord, order passed on 15/5/2023. Mr. L. Samuel, Lord and Additional Government Advocate, state that the compensation amount
Paid
has
and
already
then paid, given the statement.
my lord. On that observation, the contempt was disposed of. But till late, my lord, compensation was not paid, my lord.
No, they are showing the statement.
It is
You should have waited and found your statement correct or not.
ଆପଣ ଯେତେବେଳେ ଷ୍ଟେଟ କାଉନସିଲ ସବମିଶନ କଲେ ଯେ ତାଙ୍କର କମ୍ପେନସେସନ ଆମାଉଣ୍ଟ ଟା ଡିଟରମିନ ହେଇଛି ତାଙ୍କୁ ଅଲରେଡି ପେମେଣ୍ଟ ହେଇଗଲାଣି ଆପଣ କହିଲେନି ସମୟ ଆଜ୍ଞା ମତେ 2-3 ଦିନ ସମୟ ଦିଅନ୍ତୁ ମୁଁ ମୋ କ୍ଲାଏଣ୍ଟ ଠୁ ବୁଝିବି କି ନା ଆସିବି ଆପଣ କଣ୍ଟେଣ୍ଟ ପିଟିସନ ଟା ଡିସ୍ପୋଜ ଅଫ ହେଇଗଲା ତାପରେ ଆସି କହୁଛନ୍ତି ଯେ
ବ୍ୟାଙ୍କ ଆକାଉଣ୍ଟ ଦେଇଛି ଯେ
କୋର୍ଟ ଦେଇନଥାନ୍ତେ ଆପଣ ଯଦି କହିଥାନ୍ତେ ଯେ ବର୍ତ୍ତମାନ ଏଇ ସବମିଶନ କରୁଛନ୍ତି ମୁଁ ଜାଣିନି କ୍ଲାଏଣ୍ଟକୁ ମୁଁ ଟିକେ ପଚାରିକିନି ମତେ ଆପଣ କଣ୍ଟେଣ୍ଟ ପିଟିସନ ଟା ଡିସ୍ପୋଜ ଅଫ ହେଇଗଲା ବର୍ତ୍ତମାନ ଆସି କହୁଛନ୍ତି ଆମ ପେମେଣ୍ଟ ପାଇନାହାନ୍ତି so you mean to say in support of the proof of that you have filed your bank account?
Bank account, my lord, Annexure 9.
ଆପଣଙ୍କର କଣ ଏଇ ଗୋଟିଏ ବ୍ୟାଙ୍କ ଆକାଉଣ୍ଟ ଆଉ ବ୍ୟାଙ୍କ ଆକାଉଣ୍ଟ ନାହିଁ?
What they provided me this account, ଆଉ ନାହିଁ ବୋଲି କହୁଛି.
No, this is the account statement you have provided.
My lord,
but what about the government, the state, what
no,
statement they have provided?
No statement was provided at that time, my lord, during.
That is
Yes,
there.
yes. But
How can we see what?
so there must have
क्योंकि
been
दिया
some
क्या?
अच्छा you
That
take
was the
instruction.
instruction, yeah.
Mr. Samantrai made such a statement that the compensation amount has already been determined and paid to the petition.
For their submission that the compensation amount partly they have received.
Yes, it is balance part.
Balance part they're claiming
part time.
that is to be considered. Whether that is considered or that is rejected, and other it is considered must have been paid. It has not been considered that the previous amount which has been received.
So it is after 15/5/23.
I'll take it.
No.
That order is that has been paid to the petitioner.
ये जो amount है से वर्तमान claim କରୁଛନ୍ତି please come to the prayer. ସେ କହୁଛନ୍ତି ଆଗରେ ଏଇ amount ଟା ଆପଣ prayer କରିବେ ସେଇ amount ଟା ପାଇଁ ଯେତେବେଳେ order ହେଲା representation dispose of କରିକିନି ସେଟା କଲେନି ଆପଣ content petition ଆସିଲେ state council submission କଲେ ଯେ amount ଟା already paid ହେଇସାରିଲାଣି କହୁଛନ୍ତି ଯାଇନି ତାଙ୍କ account କୁ that is his submission ଲେଖନ୍ତୁ the land council for the petitioner submits that the petitioner so and so has made a filed this petition with a prayer for payment of the balance compensation amount of ₹50,42,500 to the petitioner in respect of the acquired land measuring so and so lekha ହେଇଛି prayer person. It is submitted that Earlier, the petitioner approached this court uh, for self-same prayer, and in WPC number 10479 of 2018, and this court, by the order dated 9/7/2018, directed the concerned authority to consider the representation of the petitioner in that respect. And since that was not carried out by the authority, a contempt petition was filed before this court in contempt number 571 of 2019. And when the matter was taken up on 15/5/2023, the London Additional Government Advocate made a statement before this court that the compensation amount has already been determined and paid to the petitioner. And accordingly, the contempt petition for contempt proceeding was dropped. It is the submission of the Land Council for the petitioner that till date, the balance compensation amount has not been received by the petitioner, and this statement which has been made by the London Additional Government Advocate before this court in the contempt proceeding on 15/5/2023 was not correct. In support of such contention, he has annexed the bank statement. London Council for the state seeks some time to obtain instruction in that respect. Put of this matter, place this matter on 11 November 2020.
Item number 7.
Yes, Mr. Rao, Bapna Motors case, we asked you to go through that para 110.3.
That's, I have examined the judgment, my lord.
Yes.
That Bafna Motors judgment. That is, in my humble submission, is not applicable to the present case, simply because the facts are totally different, and the point in the decided in that case is also not applicable so far as my case is concerned. In my case, I have come to before this honorable court directly instead of approaching the appellate DRT only on the ground that the bank lacked jurisdiction in issuing a notice in view of a provision which has come into force from 2016, section 26D of the Securitization Act, which prohibits the secured creditor from issuing and taking any steps under the act without themselves registering under the CERSAI. That is because that's a jurisdictional issue.
Just which section you said?
Section 26, capital D. (26D), right of enforcement of securities, notwithstanding anything contained in any other law for the time being in force, from the date of commencement of the provisions of this chapter, no secured creditor shall be entitled to exercise the rights of enforcement of securities under Chapter 3, unless the security interest created in its favor by the borrower has been registered with the central registry. Let that page.
What is the central registry?
Central registry is, you will also say that is sent from 26, section 26. Very good. Your lordship will kindly turn to Annexure 5 at page 97. Central Registry of Securitization, Asset Reconstruction and Security Interest
No,
in.
just come to that central registry. The definition is section 2G.
Yes.
2G of the Surface Act.
Act.
Central registry means registry set up or caused to be set up under subsection 1 of section 20.
Yes.
Now you come to section 20.
My lord.
Please read it out.
Section 20.
Yes.
Central Registry. The central government may, by notification, set up or cause to be set up from such date as it may specify in such notification, a registry to be known as Central Registry with its own seal and for the purpose of registration of transaction of securitization and reconstruction of financial assets and creation of security interest under this Act. The head office of the Central Registry shall be at such and such place. Then the central government may, by notification, define the territorial limits within which the office of the Central Registry may exercise its function. Then subsection 4, the provisions of Act pertaining to the Central Registry shall be in addition to and not in derogation of any of the provisions contained in the Registration Act 1908, the Companies Act 1956, the Merchant Shipping Act so and so, the Patents Act, the Motor Vehicles Act, and the Designs Act, or any other law requiring registration of charges and shall not affect the priority of charges or validity thereof under those acts or laws. So this the central registry is created and the registration is necessary under section 26B, capital B, chapter 4A.
The central register is there in 21. It says that central government may by notification
Yes.
appoint a person for the purpose of registration of the transaction relating to securitization, reconstruction, and
Financial assets, security created our properties to be known as central register.
The central register may appoint so and so. So 26D says, notwithstanding anything contained in any other law for the timing from the date of commencement of the provisions of this chapter, no secured creditor shall be entitled to exercise so and so unless the security interest created in its favor by the borrower has been registered with the central agency.
Yes.
So have you taken that ground?
Yes,
Where is that?
That is the only ground.
Let us see.
At page 16, sorry. At page, it starts from page 15, paragraph 17.
Paragraph 17.
17, page 15.
Page 15.
That in the meanwhile, while notification bearing number so and so, the central government has issued a notification, the Amendment Act of 44 of 2016, which includes section 26D of the Surface Act to come to force with effect from 24/1/2020. However, even after the section 26D came into force, the opposite party bank has not registered the securities of the petitioner in the central registry. The same can be seen from search report wherein the debtor based search petitioner's span is not reflecting with any securities. The search report for all these three companies are annexed as Annexure 5. At page 97, I have given the Annexure 5.
So this transaction is of the year?
This transaction, loan was taken earlier.
So
how can
it be registered?
Now this notice under steps under section 13(4)(b) were taken only now, man. This is under Annexure, this impugned notice, Annexure 12.
No, no, Mr. Rao just said that this chapter 4A, that is, which includes this 26B,
D.
that came into force with effect from
24/1/20.
24/1/2020,
Yes.
and it appears that this loan was taken, sanctioned in the year January 2013. That is at page annexure 3. At
Yes,
least it
yes, madam. Loan was
indicates
taken
2013.
earlier.
Loan was taken earlier,
Yes.
and so
But this
say that it could have a retrospective operation.
my humble submission will be this section deals with taking steps under the Securitization Act.
When this step
13.
was taken, just a minute, when this step was taken, this 13-4 notice was issued when?
No, the auction sale notice
Was issued in 2015. So by that time, this provision was not.
That was not there.
So then there is a question of.
But now the present 13-4 step, by issuing a sale notice,
obviously it would flow
Yes,
from
it will
that,
flow from
that 13-4 notice, it would flow. It is not that if you are right that if suppose the sale or the this sanction of loan have been after this 24/1/2020, you are right that it should have been registered before that central registry, and otherwise they are deprived of taking any action under section 13(4). But since the loan sanction is of the year 2015 and 13-4 notice is of 2015, so how do you say that this particular provision would have a retrospective effect? That was not existent at all in that
yes,
point.
that never came into force in 2015.
Yes.
That is correct, Bharat. But my humble submission is the section 13(4) steps include so many things.
Yes.
You'll also have a look at section 13(4) itself.
Yes.
So many steps.
Hmm.
Each step is called 13(4). Section 13, subclass 4, in case the borrower fails to discharge the liability in full within the period specified in subsection 2, the secured creditor may take recourse to one or more of the following measures. Number 1, take possession of the secured asset of the borrower, including the rights to transfer by of lease.
13-4 will go in.
B,
There
take over the management of the business, so and so. C, appoint any person. D, require at any time notice in writing any person who has acquired any of the secured assets, so and so. And 5, these are steps.
Yes, many steps are there.
What I am trying to submit is any step taken gives a fresh cause of action for me under section 13(4). So 13(4) steps are debarred from taking after 2000 when the
No, it has you yourself say, and you have already given us that this 13(4) notice is not after 2020. It was earlier issued.
2015.
It was 2015. That
But-
is your annexure number 3.
Quite
So
correct.
whatever has been done, that is just a follow-up action.
Follow-up action, my lord. But this issuance of sale notice is also a step under section
Right,
13.
obviously. So
Therefore, this step is not entertainable.
that is also
what your lordships, what falls from your lordships,
Yeah.
that from 2015, what all steps are taken till this section came into force, they were valid. Then I have never raised this question.
Yeah.
On other points, I was agitating. Now, after this section came into force, they are bound to register it.
No. Obviously, this provision, two things. This provision cannot 26D cannot have any retrospective operation. So once that has started means every proceeding under that act would go as if this was non-existent then.
Quite correct, madam.
Right. So any transaction of grant of loan after that particular date, then obviously 26D would be applicable. So any transaction made prior to that,
Partly on this.
13(4) notice 5 years prior to that, So by that time, this was non-existent. So question of and
But-
whatever follow-up action, right? You said
Quite, I understand your lordship's point, Mirat. But can we go into sections 26D once again?
yes.
Notwithstanding anything contained
Yeah.
in any other law for the time being in force, from the date of commencement of the provisions of this chapter, that is in 2000, after the chapter section came into force, no secured creditor shall be entitled to exercise the rights of enforcement of securities. When grant of a security, taking his property as a security, becoming a secured creditor, all those things were before the section came into force. Now the question is relating to enforcement. Enforcement can
So,
be
Mr. Rao, 13.4 notice is not a that is it not a exercise of right of enforcement?
that is one
of
step.
right?
That is
the first step is to be taken.
that is one step.
Of course, prior to that, 13.2 is to be
there.
taken. Then representation to be
Quite
made
correct.
13.3a. Then 13.4 comes. So that goes step by step.
Right.
So it flows from that.
That quite correct, Marat. Marat, if we go to the history of this case, Marat, after that 13.4 notice, what has happened? I have taken loan from the Andhra Bank. This was taken over by the present opposite party bank. Then the present bank issued a notice saying that the Andhra Bank has committed fraud and started a case, vigilance case before the magistrate. And I was also noticed, and I moved anticipatory bail, and again I moved the honorable matter went up to the Supreme Court. Honorable Supreme Court took note of all these things and said that let all the cases be withdrawn and the OTS that was earlier sanctioned in my favor may be enforced by giving a time limit. So that earlier 13.4 notice and all those developments that took place came to an end after the Honorable Supreme Court has said that you give them time and they will discharge the loan. And the obligation was put on the bank also to release my properties so that I can sell and deposit the money. Bank took a view that they will not release the properties. On the other hand, they have published the notice here and there, and I was unable to raise funds also in the market because my reputation was at stake because a vigilance case has been against me. At that point of time, I sought for an extension of time from the Honorable Supreme Court. Supreme Court granted some time and also they asked them to release the properties. Still, they didn't release the properties. And thereafter, again, when I went for extension, Honorable Supreme Court said that no, we can't go on extending this matter. You have your remedies elsewhere. So that is how that chapter ended. Thereafter only the present notice was given for enforcement of the security. Therefore, in my humble submission, whatever cause of action was there earlier, whatever steps they were taking earlier, that came to an end once the matter was placed before Honorable Supreme Court. And thereafter, the fresh notice which they have given is the enforcement now. This is after the act of
it all relates to that. It's not that.
But if your lordship will take a view that initial step taken by them, that loan has been declared NPA and all those things, then matter would be definitely, as your lordships are thinking, that it will be a continuation. But in my humble submission, enforcement means the enforcement begins once the sale, each step. 13.4 gives several steps. At any step in that Asoka Industries case, your lordship knows, everywhere it is said that at each step I can challenge under section 17. Therefore, each step taken for enforcement is an enforcement. The section 13 deals with enforcement. So any step taken for enforcement is an enforcement. And enforcement, when the enforcement step is taken,
now
the law on the land
at the stage now, Mr. Rao, what is the stage now?
The stage is yesterday the property was put for auction.
Yes.
Out of three matters are there. Item 7.
What happened? What happened? Successful.
That is relating to, I don't know
No,
the,
this is the respondent's development.
that's right. That's
So now
your
third
lordship,
party right has already been created.
that's right.
Without
That,
hearing, can we?
but once initiation of
It
this,
is, that is why we
I
put
quite
a query, made a query to him that what happened yesterday.
Yes,
He
yes.
said that it has already been.
That's
So
what he is
can we-
informing. We will not know it later. But the question, my humble submission before your lordship is, merely because auction is held, it is not the end of the matter. Sale has to be, they have to deposit, sale has to be confirmed. So many things are there. I don't say that.
So,
But
that
what I'm,
you are taking to that old section that
Hmm.
has been referred in that Bafna Motors. That
No,
it
that-
is not that until it is finally.
no. That
They
Bafna
say
Motors,
that once this new provision has come, the moment it 13.4 notice is issued, matter ends there.
no. What the Bafna Motors says is 13.8 is an amendment.
Yes.
That says the right of redemption is lost. That is not saying where the notice itself is defective, where the notice itself is without jurisdiction. That can't be entertained. It's not that. I cannot say that I will pay money and take back the property.
No, but then the jurisdiction of this court,
Jurisdiction of this court,
jurisdiction
your
of this
lordship
court
knows
is
well that-
already that is set at rest. That is set.
That's right. Your
So
lordship,
that is how we cannot.
your lordship is fully aware of the matter that in a case where the question of jurisdiction has been raised with the authority having no jurisdiction at all,
No,
this honorable
jurisdiction is
court
there.
will always interfere.
No, how you say that jurisdiction was not there with the DRT?
Not with DRT, my lord. No
Enforcement
jurisdiction
authority.
is there with the authority,
Yes,
blank.
enforcement authority.
Yes. The enforcement authority had no jurisdiction in issuing notice.
Sir, now it would be better we'll just dispose of recording his submission, giving you liberty to upload the otherwise because the that third party right has already been.
Third party right, there's 4 properties or 5 properties.
No, he is making a submission. If you want to verify, you can verify. If you don't believe his statement, he's making a statement. He's making a statement.
Let him make a statement on how many properties were sold, whether all the properties were sold. He can't make that. Because yesterday itself it was there.
Yes, that's one.
All right. After this
This
question
question
has been filed.
Question which cropped up, my lad, before this honorable court.
This was before by the petitioner challenging the order declared.
But there is one judgment of Guwahati High Court, of course, subject to whatever lordship's consideration. There also, this 26D question came. There, what has happened? That was the property auction relating to 2016. But the honorable High Court has said that no, the section 26D is a bar.
No.
But this is a question to be examined, my lord. What I am trying to submit before your lordships is, I have not come up with a case which is devoid of total merit, my lord. I am trying to place before this honorable court a point.
So, Mr. Rao Lenin, a senior advocate, submits that in view of section 26D of the Surface Act, which came into force on 24/1/2020, the secured creditor, which in this case, in this writ petition, is opposite part, they are the opposite parties, are not entitled to exercise the rights of enforcement of securities under Chapter 3 unless the security interest created in their favor has been registered with the central registry. The Land Council submits that it would be evident from the letter
Annexure 5.
that it has not been registered under the
Page 97.
Brought to the notice of the court, the Annexure 5, which is the central registry of so and so research report to substantiate his contention. However, it appears that the loan was sanctioned in the year 2013 and the first 13-4 surface eye notice was issued in the year 2015. And therefore, we are of the view that Section 26D, which came into force on such and such day 24/1/2020, cannot have any retrospective operation. Moreover, in this case, the auction sale notice has been issued, and in the case of Bapna Motors, it has been held by the Honorable Supreme Court, Court's paragraph number 110.3. Learned Counsel appearing for the opposite party submitted that yesterday the auction sale proceeding is over, and the successful bidder has been determined, and the follow-up action is to be taken, right? He has to deposit the balance amount, etc., right? In view of such state of affairs, we are not inclined to interfere with the impugned order. The petitioner is at liberty to seek alternative remedy in accordance with law. Yes.
And one more submission of mine may kindly be recorded.
Yeah.
That this presents notice and is also a step under Section 13(4). Therefore,
I just put it like that for me. The Learned Counsel for the Land Senior Advocate further submits that earlier 13-4 notice has been set at rest after the passing of the order of the Honorable Supreme Court on Supreme
Court. I have extracted. We have extracted them. This one.
Which is the order of the Honorable
30/10/2023.
30/10/2023.
23.
30/10/2023, that is by Annexure 8. And thereafter, since this 13-4 notice has been issued on 5/10/2024. Notice
Yes.
5/10/2020. Auction sale notice was issued on 5/10/2024. This Section 26E provision would be applicable. Yes, next.
That your lordships have recorded 13. It was 30, 30. Date
30/10/2023.
13.
We'll correct it. So similar order is to be passed in the other cases.
10 and 11.
10. This order, which is there in item number 7, similar order is to be passed. It is in case of other companies. That is 10, then 11 and 12.
Yes.
10, 7, 10, 11. 7, 10, 11. Okay. Disposed of.
I believe your lordships have granted liberty to.
Yes.
But I mean, pardon your lordship will rise at.
Yes, we are just right.
More item number 13 may not have.
We take up on Monday.
Yeah, very good.